All right, welcome everybody. Glad that you are here. I am going to basically I'm going to watch the Judge Boy's hearing for Chad Daybell related to some several different motions. I guess probably the primary one is cameras in the courtroom. I've already done one live about it where I just commented on what happened, my opinion on it. I like what these Idaho judges are trying to do. They've kind of pushed court TV out. Mainstream media is no longer in charge of the cameras. Now it will be court appointed, like employees or officers of the court that will be running the cameras. And I think it's a really good move. I think it can go a long way. Hey, DB, welcome. I think it'll go a long way for making these Idaho getting more access into the courtroom if the judges feel like the control is in their hands rather than having to go to some big media conglomerate in New York City asking them, please don't do this and please do that. So I think it's a good move. I think it's something that's very unique and different. We are not really seeing that in any of the other states, but they may actually have come up with a really great idea. So that's where we are. So I am going to be quiet now. I'm going to start the hearing, and I'll probably let's see, it's 6 o'clock. I don't know. We may get all 4 hours in. Probably going to do 2 hours and then end it. Do that as a part one. Tomorrow evening, I'm going to come back and we're going to finish day one of the Daybell preliminary hearing. We already did the first half. We're going to do the second half of day one. Then by the weekend, we'll be at day two. So I know it's kind of choppy, but I have a reason for doing this. So I'm going to let this play. And if you've watched it, great. If you want to stick around and watch it again, I'd appreciate it. Otherwise, have a really great Sunday night. All right. All right. Here we go.
Scheduled before the court are various motions, including a motion as it relates to a reconsideration of the court's previous order on video and photographic coverage of the trial in this case. That's scheduled to be heard this morning. We've also got the state's motion to amend the indictment, the state's renewed motion to reconsider change of venue. We've got the defendant's motion in limine, requesting a motion in limine to limit the state to consistent arguments. There's also two additional motions filed by the defense relating to a request to strike the death penalty in this case. So we'll take these matters up in the order I just announced them. So let me just inquire first, starting then with the reconsideration of video and photographic coverage. Is the state ready to proceed with that motion?
Yes, Your Honor.
And who will be arguing that?
I'll be arguing that motion.
Very well. And then is the defense ready to proceed on that motion? Yes, Your Honor. All right. I'll note also on that motion, the court will permit and has considered briefing that was submitted by interested parties. Wendy Olson representing those interested parties who will be allowed to submit argument for today's hearing. Is Ms. Olson present here? I am. Thank you. And you'll be presenting argument today in addition, is that correct? Yes, Your Honor. All right, the court will permit that as well then on the motion. So we'll start then with procedurally on the motion. The court had entered a order in the what used to be the companion case of 22-21-16-24 State versus Lori Vallow, and that applied to both cases. The court thereafter had concluded that when that trial was complete, the issue of coverage would be reconsidered here, mostly for the reason that there was a mutual request in the Lori Vallow case, which the court considered, and the parties are in a different posture here where the defense has requested that the court permit photography or video of the trial here. Mr. Pryor on behalf of his client, and we're at different proceedings, a different case now, and that other case has been concluded. So based on that, the court mentioned to counsel in a status conference that we would address the issue today. And then I issued an order on October 11th that we would hear argument on the issue today concerning camera coverage of this case continuing, as well as the trial that's scheduled for March of 2024. So at this time, the court would note I have reviewed the briefs. I'll begin with the state's argument on the issue here. After that, I'll hear from the defense, Mr. Pryor, and then finally after that, Ms. Olson, if you'd like to make any argument on behalf of your clients, you can do that. Mr. Wood.
Your Honor, respectfully, I'd actually ask that we reverse that order. This is technically the defendant's motion, and the interested party agrees with the defendant. The state is in a responsive posture. We'd ask to be able to go after them to be able to respond. That being said, if you want me to go first, I can go first. I just think that would be the appropriate manner to proceed in.
All right, and I don't mind switching the order given that. Mr. Pryor, your thoughts?
Well, Judge, my thoughts are simply this, is that unlike the change of venue, which was the prosecuting attorney trying to have a court reconsider a motion without any lawful authority, because in the venue, there is no lawful authority for them to hear a motion to reconsider. In this particular case, it was the court's own initiative that said that given the posture that they would do a motion to reconsider, and the court is well within its right to do that. In essence, what it is, Judge, is it's a first-time motion to allow cameras, and as such, I think that it's proper that the state go first and followed by the defense and Ms. Olson.
All right. Quite frankly, I'm not sure that the order matters that much in terms of how persuasive the arguments would be. I would note it was the court that raised the issue sua sponte in its order to review the issue given where we're at. Mr. Wood, I'll hear your argument at this point, and then I will hear the response from the others. I'll allow a rebuttal, however, after they've made their arguments. So if you'd like to present argument now, you can.
Very well, thank you, Your Honor. So the motion before the court is whether or not we allow live broadcasting or cameras into the courtroom. And I want to start out, I understand these are adversarial proceedings. We do not, the state does not see the media in any way as an adversary. We are grateful for the media. We respect the media. There's a reason why the right to a free press is in our Constitution and one of the first things mentioned in the Bill of Rights. We understand they have an important role in preserving government transparency. They have an important role in informing the public. And so we do respect them. This argument is not at all about whether or not the media should be allowed in the courtroom. They should be allowed, and we're glad they're there. In terms of broadcasting the trial, and the state at least is going to address broadcasting the trial and broadcasting any further pretrial hearings. We shouldn't fix what isn't broken. This court made a very good decision. I believe it was in September or October of preceding of last year. And we think the court was correct when it made that decision. We think that that decision led to more professional proceedings and helped in preserving the rights to the parties, the rights of the parties to a fair trial. Again, we're not arguing that the media should not be allowed in the courtroom. In our brief, we talk about that. The right of the public and media is important in the courtroom.
Well, we having some audio issues or something?
For some reason, Sand and Leanne can't.
Trial gets aggressive. And then to have that added pressure of knowing My next door neighbor can watch this. The people I go to church with can watch this. It's not conducive, especially in a case like this, to a fair trial for either of the parties. We understand that the defendant has a different position on that. We believe strongly that having live broadcasting this trial only makes it more difficult to get to the truth of the matter. As stated before, we do not believe that visual broadcasting is necessary for a transparent and a public trial. We believe in an open and public trial. Transparency does not require mass publicity. And there's no rule, there's no law that says that it does. And I would note, and I put this in my brief, at the last trial, at Lori's trial, there was a lot of reporting, and it was minute by minute. I called it live tweeting. I don't know if there's a specific other phrase for that, but where multiple reporters in the courtroom or in the auxiliary room were able to live tweet, and that was great. I fully support that, and in as much as we are able to follow it, it appeared to be very accurate and timely. And so the public, the interested public, was able to follow by the minute what was happening in the trial. They didn't need to watch it. They still got that information. And again, as far as the state could tell, it was accurate information. It was a job well done by the individuals reporting on the case. And so not only that, there's a transcript. People can obtain the transcript. There was an audio recording that was provided at the end of each day. And so in terms of a transparent and public trial, we don't have to point cameras in people's faces for the trial to be open, transparent, and public. I would quickly note, the state is aware, many of the victims in this case feel differently than the state. I know there was news articles about that last time. We don't technically represent the victims. We respect them and their desires, and it's appropriate for the court to know they don't necessarily agree with us on this. And so if we keep the status quo, if we keep it where it's at, there's no risk of a non-public trial. There's no risk of a non-transparent trial. The state doesn't see an upside to bringing cameras into the courtroom. It worked well the last time. Again, we shouldn't fix what isn't broken. And I put this in my brief, and if the court decides to change its decision, we respectfully request a few things. We would ask, this hasn't been an issue lately, and it wasn't an issue at the last trial, but just, I guess, preemptively, we would specifically request that no media microphones be placed at counsel's table, as took place in some of the other pretrial hearings. We believe that violates Idaho Court Administrative Rule 45C, or at least has a very grave ability to violate that rule. We would ask that the court consider alternatives to live visual broadcasting, such as still photography. And should the court allow visual broadcasting, we would ask that the court essentially retain tight control on that, at least while it's being done. As this court is aware, once video is made and public, the court loses any and all control by rule over what happens with it. But we would ask that the camera placement be limited. We think a good model would be Ms. Vallow or Ms. Daybell's sentencing, in which I believe there was a camera on the court and one camera pointing at the parties. There was no zooming in on attorneys, on witnesses, on victims. And so we would ask that if the court does change its decision, that it do so within that framework to maintain the fairness of the trial. Again, we do not believe that live broadcasting is necessary. Thank you.
All right, thank you for the argument, Mr. Wood. Mr. Pryor.
Judge, The primary reason for Mr. Daybell requesting the cameras is to allow his family to view the proceedings. They would like the opportunity to watch on TV and to see how the trial transpires, and those children that aren't going to be witnesses would like to be able to do that. It's extended family as well. That's our primary reason for doing that. I'm concerned about live streaming because that allows, in my opinion, less control. Cameras, in addition, in the courtroom, we'd lose a little bit of control as well. But I'd be more concerned about a cameraman who's, while this thing has been proceeding, has snapped 1,000 pictures of me and Chad while we're sitting here. That's a bigger concern for me than the actual cameras. We can't control what this cameraman's doing and pictures he's taken. He's been snipping along, and I'm sure I'll be seeing them with Mr. Eaton's website later today or tomorrow. The court, however, can put some conditions on a live camera. And on a live camera, like Mr. Wood pointed out, and I wholeheartedly, and quite frankly, Mr. Wood, I agree almost with everything you say. He makes a good, valid argument, Judge. However, the overriding concern is that when our founding fathers started the process of deciding that there would be a public trial, we didn't have cameras. We didn't have ability to broadcast this. And the idea behind a public trial was that if you brought allegations against someone and they wanted to answer those allegations, they should be able to do that in a public forum. And the state of media and the amount of attention, and and I do disagree with Mr. Wood. East Idaho has been saturated with media attention on this case, but the reality is this is a national case. It has garnered tremendous attention. And a public trial is just not limited to people coming from Fremont County to sit in the courtroom and watch the proceedings. And having sat through the entire trial of Lori Vallow and watched the entire proceeding, there were issues with the live feed. I'm opposed to the live feed. I just didn't think it worked. It wasn't pragmatic. It wasn't practical. I think that let's use the professionals who know how to do this. I don't like the idea of a camera being pointed in my face for what's going to end up being 8 to 10 weeks. I dislike even more a photographer taking pictures of me while we're sitting here. And I'd much rather have a cameraman with that. And Mr. Wood pointed out some of the restrictions that we could apply. And I agree with what he said. No mics at the tables. I guess if you have to point the camera at Mr. Daybell and I, go ahead, and Mr. Wood and his group as well, and at the witnesses. But part of the reason behind the public trial, Judge, is accountability. And that's a big overriding factor. And when you're talking about due process and people having a fair right to a public trial, accountability is important. And as much as I don't like the idea of being on live TV, national TV, and I don't like the idea of it at all, the reality is it keeps everybody honest. It keeps the system honest. It keeps the witnesses honest. It keeps everybody honest. And and I'll disagree with Mr. Wood in just this regard. The fact that you have a camera on you, the fact that people are watching this in a public, much like when our founding fathers, you had to answer questions in a public forum, that makes the system honest. And that really is what the driving force, Judge, is allow the public to see this in an honest way, be able to see the entire evidence, not what press releases that people are releasing, not what certain news media report. Let's allow the public to see this in a public way and allow what really is should be a public trial. And again, allowing Mr. Daybell's family to review the proceedings, you could imagine, Judge, that if they show up to court, they would be inundated, whether it was here or anybody else, with the media hounding them and the victims as well, and everybody.
Who's your daddy? There you go, Vicky. Golly, I had forgotten all about that. There does continue to beg the question, why is it that Mr. Pryor and Chad Daybell look so dramatically similar. Like they definitely are sharing some DNA. Don't you guys think? If you guys think that Pryor and Daybell are sharing some DNA, put on. Who's your daddy? Anybody? Hey, Donna. Hey, Vicky Carpenter. Fancy. Martian Planet Art. Welcome. Hey, Justice Jane. You are being a trooper tonight. Yes, they look so much alike. It's Chatty Daddy. Fancy Nancy, you kill me with your rhymes. Oh, Chatty Daddy. There you go. Okay, so the reason I interrupted the feed is this. I agree with or Chatty Daddy. I agree with him on this. I think that this is really kind of my one this would be my one argument why I do think that in 2023 that we should have cameras in the courtroom. Okay? And it is this, that in today's world, people have friends and acquaintances and most important, family all over the globe, not just across our individual countries, but really we're quite a the nuclear family, we're quite a dispersed group. It's a rare thing now to have a multi-generational family living in one town or in one geographical, region. Most of us will get educated in one city and then we travel to another city to make our fortunes. And then after we get ready to retire, then we go back to the small town we were born in. So there's a wide, that was one of the big problems with the with Charlie and Kay Woodcock, that they had Charles Bellow had a lot of family in Louisiana and Texas, and it just wasn't feasible. That just couldn't be managed to be in, Idaho for 6 weeks. It was very difficult for the immediate family members to do that. We saw the same phenomenon with Jodi Arias, the death of Travis Alexander. He has a large family, and they were from, I believe, was it California? I think. So many of those kids or siblings, many of them lost their jobs, but they were committed to being in that courtroom in Arizona every single day and see it through, not just through the guilt, the guilt innocence phase, but also the death penalty phase. And that can be a couple of months long, so in 2023, we have a great dispersal of family members, many friends. We're a very mobile world. And so there are people that really are invested in these cases. Same thing with Gannon Stalk when he was killed. They had family and loved ones spread far out from Florida all the way to Colorado. And so because of that, I think that it is, I think it's in keeping with the Constitution and that crossroads of context where we're in 2023, we're living in the world of technology. I think it is the right decision to make the information, to make the court proceedings open and available to all the people that are affected by the crime. And the second part I agree with him on is it keeps people honest. We all know that. We all live by it, every one of us. And nobody has to walk around being an angel and being perfect and all that. But there are some circumstances where the outcome is so dramatic and so critical that you don't want to leave it up to the chances of just, personal morality and ethics. if a couple of cameras in a courtroom can keep a judge making good, solid, constitutionally based decisions, then by all means, put it out there. Let's see it. If that's the only thing to make that judge stop and think, okay, wait a minute, I could go both ways on this. And maybe personally, I'd like to go this way, but constitutionally, I should probably go the other way. If that camera is rolling, guess what that judge is going to do? He's going to err on the side of the United States Constitution or the state constitution every time. So it's not that I'm saying that judges are not honest. I think probably realistically, of all the roles in society and all of the people, probably judges would probably considered among the most honest and exact of all professions that there are. But still, just because the Constitution calls for open public trials, it is in fact the state that tries these people. It should be open, just the way the U.S. Constitution is written. So I can't believe it, but I do find myself agreeing with Chatty Daddy. Yep, and that's a little disconcerting. Amber Heard sure showed how she really was. Vicky, thank you for bringing that up. There's an absolute perfect example. Johnny Depp, love him or hate him, he was one of the, what was he, fifth on the world's most recognizable face, the world in history. His face was more often recognizable than Jesus. Think about that. So you have this guy who really was quite special, unique human being. With never an accusation in the history of his 50 some odd years of life, never, not once, an accusation of him being aggressive, violent, rapey, none of that, never. And he marries this crazy woman, and I don't mind saying that because we've all seen the videos. We got the t-shirt to prove it, right? He marries her, and she is the epitome of gold digger, basically. And I think she thought she was going to use him and his fame, his good reputation, to get a leg up into Hollywood, and that she would be the next Nicole Kidman. The problem is she lacks that talent. It's not there. She's not a unique human being. She is no Nicole Kidman. But he fell for it. And she really set him up in a horrible way and really ruined his career. So had we not seen the actual trial, had we not seen the actual witnesses and the attorneys, had we not seen that, it would have been another just common everyday case of one person lying against another person and destroying their lives. That's what it would have been, a common tale. And unfortunately, or fortunately, depending on who you ask, we're in an age and time where if a woman makes an outcry, your name is mud if you try to question if she's telling the truth. Your name is mud if you try to suggest, well, maybe, could you have misunderstood? Or you're not even allowed to do that. You can't. It is just like it in the case of children. And I stand by this. If a child makes an outcry, they don't have ulterior motives that adults do. If a child makes an outcry, you better start listening because they're going to tell the truth. But sometimes girls, women, I think it's rare because I think that it is a horrible process to make an outcry and to be questioned by police and then try to go through a trial and people inherently don't believe you. So it's pretty horrifying. I would say 9 times out of 10, a woman who's willing to put herself through that, subject herself to that, they're telling the truth. But in this particular case, remember what I said about, factors that lead to dangerousness, potential consequences, right? Did Amber Heard have something to lose? She really did. Not only did she have a lot to lose, she also had an incredible amount to gain. That if she were believed, then she would be the world's next, trying to think of somebody. She would be upheld as a woman's rights, queen. So it was terrible. When we heard the evidence of how she really manipulated the deaf children, it was terrible. It's awful to imagine his daughter, how badly she was manipulated by these people. And the one thing that came out of that trial that really surprised me was how Amber's friends that moved into the penthouses, that Johnny Depp just said, come live here. I don't care. Use my driver, use my cars. I'll buy the food. Everybody live here, be happy. They were all just mooching off of him, off his generosity. And yet it seems that they were there in order to set him up. Like they were all in cahoots, right? It's very uncomfortable. It's a very bad thing. So when Johnny Depp says, I have no use for Hollywood, I think we should probably believe him. Hey, sweet crazy. How are you doing? It's good to see you. So, so in this case, who's your daddy? I think he got it right. I think number one, having the cameras in the courtroom, it allows all of the family, extended family, friends, interested parties that want to be a part of the public trial. It gives them access to watch. And we are a culture where there is a great deal of mobility. So very few of us live in the same location as other family members. And then the other part is it's just the United States Constitution. So yeah, chatty daddy. I think you got it right. I'm going to be quiet now.
Everybody else who's involved in this, allowing them people to watch this in a public setting, there is one caveat. By doing this in a public with live cameras, Judge, that does create a concern for whether or not witnesses are watching the proceedings. And I guess I don't know how the court would address that, and that's something the court does need to look at. That doesn't change my position that I believe it should be a public hearing with cameras, but controlling how witnesses are limited in watching the media, and maybe the prosecutors and I could work out something with all of our witnesses saying, absolutely no opportunities to view this. If the court allows this to be a public trial with cameras, there's going to have to be some sort of an order that advises all of the witnesses that they are not under any circumstances to review the proceedings or view the proceedings.
And isn't it true? We don't really lock our juries down anymore, do we? Like you never hear about a sequestered jury ever. So I don't know. It's already on the merit system. Already, we're in a period of time where we all got the internet. We've all got instant news. We can all jump on Twitter and find out what's happening in Los Angeles or Bangor, Maine in 2 seconds. It's just the reality of the world we live in. And they go by the honor system. The judge just says, hey, don't follow the case. Don't watch any news concerning the case. Don't read anything about the case. So they do that to the jurors. They go home every night. They've got family members. They're watching it. The family members are watching. But I think individual jurors have the ability to do what they're told by the judges. And now I guess that simply will extend to witnesses. And I think that's just where we are in 2023.
So that is a concern of mine, but I still stick with our original position that we need to have cameras in the courtroom, Judge. Thank you, Your Honor.
All right, thank you, Mr. Pryor. Morning, Ms. Olson. I'll note now we'll hear argument from Attorney Wendy Olson, who's representing EastIdahoNews.com, the Idaho Statesman, Idaho Press Club, and States Newsroom, doing business as Idaho Capital Sun. Brief's been filed. The court's reviewed that, and if you'd like to present argument in support of your position, you can do so at this time.
Thank you, Your Honor. And thank you for allowing my clients to be heard this morning. As the court noted, the clients are 3 Idaho-based news entities, and then the Idaho Press Club, which is an association of journalists who work on a variety of First Amendment matters to ensure that they can have complete coverage of matters of important interest in the state of Idaho. Your Honor, the entities request the ability to have live audio and visual coverage of the proceedings in this case, consistent with Idaho Court Administrative Rule 45, in a way that will allow the defendant and the state to have their constitutional interests protected in a way that is designed to respect the privacy concerns of jurors and the sensitivities of witnesses, and to really observe the dignity of the courtroom. And I think, Your Honor, that the media entities that are before you here have done that in other cases, and they would want to work with the court on any restrictions the court thinks is important to maintain the dignity of the courtroom, to ensure that sensitive witnesses, maybe only their audio is heard at the time. They would want to work with the court to ensure that whatever guidelines the court imposes, that they would follow. But they think it's important to have cameras in the courtroom and have live audio visual coverage of the proceedings for several reasons. Primarily among them, Your Honor, it's the point that Mr. Pryor touched on, is that we are in an age now where visual coverage of just about every aspect of public life is there, where people really have the opportunity to see with their own eyes, not by sitting in a courtroom, but by sitting in their living rooms or sitting in their offices to watch those proceedings. The Kyle Rittenhouse trial had extensive coverage, TV coverage. Certainly the Derek Chauvin case did. That started out of COVID, but the judge after that realized the importance of having cameras in the courtroom. And then more recently, the Alex Murdaugh trial in South Carolina, where the coverage there was basically from the opening of the trial through the sentencings. And I think that the coverage in those cases showed how, with guidelines from the court, it allows the public to observe firsthand what goes on in the courtroom. I know the court indicated that you read our submittals, our pleadings. I would also ask the court to take particular note of Rebecca Boone's declaration, and where she talks about, she's worked with Idaho courts, Idaho journalists, law school, to try to improve coverage of our court system. We learn a lot in the public about the executive branch and the legislative branch, but less is known about the judicial branch and how it operates. And I think it's important for people to be able to see firsthand what happens in a trial, how is evidence presented. I think it's important, to the point that Mr. Wood raised, that it's important for them to see the impact that participating in a trial demands from the people who participate in it. It is no doubt, Your Honor, that the criminal justice system, the system that I participated in for most of my legal career, is very hard on the participants. It demands a lot of people. It demands a lot of the lawyers, the court, of the jurors, of the witnesses, of the family members. And I think that covering the proceedings live will allow the public to understand that better, because it is still a relatively rare thing for people to have firsthand involvement in any aspect of court proceedings. I think secondly, Your Honor, why it would be important and helpful to the court to have live audio and visual coverage is it would reduce the demand, frankly, for space in the courtroom. It's my understanding that the attendance at this hearing by the public is less than in past hearings, and maybe that's because the court elected to broadcast this live through the YouTube channel that the courts have used. Certainly, that will help the court with security and with other administrative needs and getting the trial done in a way that is most efficient. And so we think for that reason as well, it would be important to have live audio and visual coverage of the proceedings. And finally, Your Honor, with respect to how that is done, again, the media organizations want to make sure that they are working with the court on all of those things. And I know that the proceedings are being done through the court's technology today, Well, I would invite the court to not do it that way at the trial if the court allows visual proceedings. And that's really for several reasons, Your Honor. First, it is because the journalists who are experienced camera operators, typically who will do the pool reporting, they have more sensitive cameras, better cameras, and more sensitive microphones. They could be placed not at counsel table, but somewhere else if that is the court's direction. In addition, Your Honor, the court would not have to worry about whether or not there are any technical glitches if the cameras are being operated by the pool camera reporter. Of course, neither the parties nor the court nor the jurors nor anybody would want to have interruptions during the proceedings because there was some glitch in the technology. And then I think, Your Honor, again, with having the members of the press who are experts in operating their camera, they would work with the court to ensure that there isn't anything unnecessarily intrusive if they were the ones to operate the equipment, as was done, I think, at Ms. Vallow's sentencing. And so I think for all of those reasons, Your Honor, our clients would like to see the live audio and visual coverage of the proceedings. I well understand, too, both Mr. Pryor's and Mr. Wood's concerns about witnesses watching things that they should not watch before they testify. There's nothing sort of less comfortable as a prosecutor to know your witnesses have received outside information, and then that comes in at cross-examination. And of course, we want to make sure the jurors aren't watching the proceedings. With respect to the jurors, Your Honor, and them reading coverage of the case once they've been set, that's a concern in every trial. The court gives firm instructions about that, and I think as media has evolved, the court's instructions on those issues have had to change over time to include, for example, social media. I know in the federal courts, there's a social media instruction that's given all the time now about don't look at social media when you're a member of the jury, and this court can certainly craft instructions that would cover all of the concerns the court would have with respect to the jurors potentially watching anything that comes from the live audio and visual coverage of the trial. Of course, hopefully they wouldn't be watching while the trial was going on. And then, Your Honor, with respect to the witnesses, it really was incumbent upon the parties, and Mr. Pryor alluded to it, to speak to their witnesses and firmly instruct them not to watch and not to be influenced by any other evidence. It's no different than telling them don't talk to other witnesses about their testimony. It's important that their testimony be from their own independent recollection. And those are challenges that are present in every kind of case, and here they're even more so because of the prior trial of Ms. DAYBELL. And so we would ask the court that in considering those factors, do the things that the court and the parties typically do, which is to give very firm instructions. Thank you, Your Honor.
All right, I do have a few questions for you, Ms.
Sure.
Wilson. Reading through your brief, you go through some policy arguments about why it's important to have cameras in the courtroom for these proceedings. One of your captions is, it will help enhance the public's understanding of court proceedings and promote respect for the rule of law. I'll note in my background, I did some federal criminal defense work. I was a CJA attorney for about 15 years, and I believe you were the U.S. attorney for Idaho during the time I was CJA attorney. In the federal courts, they simply have a Rule 53 that there is no permitting of any photographs, any video at all in any federal proceeding. Is that your understanding of how the federal system works?
It absolutely is, Your Honor, and I'm cautiously optimistic that that rule will be changing some. I think it takes sort of a major case with a lot of public interest to move things that direction, and I suspect that the federal charges pending against Donald Trump and others, there is now a lot more just discussion in the media about changing that rule. One of the things we cited for the court was a poll about people wanting to see live coverage of oral arguments in the Supreme Court. I understand that appellate arguments are different animals from criminal trials, but I think the federal system is far behind the state system in terms of allowing coverage of what goes on in trials.
Okay, well, I want to understand that because Idaho leaves it at the discretion of the judge under Rule 45. Some other states want cameras in and have rules governing that. The entire federal system completely bans cameras, and there are high-profile, important criminal cases of great public interest occurring all the time in the federal system. Would you agree with that?
I agree, Your Honor.
And in all of those proceedings, there are never cameras because it's prohibited by federal rule. And so the policy arguments that the public is not going to have confidence in this case or an understanding of what's happening. I just wonder how that's squared with whatever policy drives the federal courts to just simply disallow cameras and take it out of the judge's hand. Don't you think, in fact, the public can still have that same type of confidence in the proceedings and understanding if they want to come and sit in and watch a trial as they do in any federal case?
Yes, Your Honor. I think certainly people who come and watch trials and see sort of firsthand what is going on, and we certainly had those in the federal, we had people who were just sort of trial watchers who would come and watch every trial, and particularly the ones that add a little bit more notoriety, and certainly those individuals well understood what was going on in the courtroom. Not everyone can do that in every case, as Mr. Pryor has outlined here. The family members of Mr. DAYBELL are not able to travel to Boise for a 10-week trial, and I understand there's a motion pending to change that for now in Boise. And I think obviously the federal government is not always ahead on policy issues of state courts or state governments on anything. And I think, Your Honor, my understanding is the federal rule is largely driven by the federal judiciary and wanting to ensure there are no cameras in the courtroom. And I think that will be changing as well, Your Honor. I think we're in a day and age where it is just the case that people want to see it with their own eyes. And federal courts are behind the times on that. And so there's a lot more work that needs to be done by people in the federal system, whether it's judges or former U.S. attorneys or criminal defense attorneys, to be able to articulate what goes on in those criminal courts. And there just isn't that I don't think it's good of an understanding. And I do think there have been concerns expressed about outcomes in criminal cases and what it means. And there's a lot less direct information available for people to base that on.
Well, Ms. Wilson, I really appreciate your comments on that. It's really interesting to hear your perspective, having been on both sides of state and federal litigation and this issue. Clearly, there are policies in place in our state courts that maybe are different than they are in the federal courts. So thank you for the well-briefed argument and your oral argument today.
And I thank you, Your Honor, for the opportunity to present argument and the opportunity to appear in Fremont County, which is a great courthouse. Thank you.
All right. Thank you, Ms. Olson. Mr. Wood, I will allow a rebuttal argument just from the state at this juncture based on the posture of the case and the comments you made at the beginning. If you have any rebuttal, it's not required, but if there's anything you'd like to add, I'll hear that now.
Just very briefly, and appreciate council's comments. Mr. Pryor did bring up a point that I put in the brief but did not bring up, but it is important to note. And Ms. Olson addressed it as well. And the state's position is by broadcasting a trial, it only makes it easier for potential witnesses to make a mistake of seeing something they shouldn't see, of hearing something they shouldn't hear. At the last trial, this issue came up with a few witnesses, and that was just the audio. The state sends out something with every subpoena. We communicate to every single witness, you're not to watch or listen to any of this trial. Sometimes things still happen, and then we have to deal with that in court, and it takes time away from the jury, it takes time away from litigating the case. This is a long trial. I don't know if it's true. I've heard that the preceding trial in this case was the longest criminal case in Idaho state history. I don't know if that's true, but I've heard that. But this will also be a very long trial. This will probably be a longer trial. Broadcasting that length of a trial, we just really run the risk, no matter what we say to witnesses, of people hearing things, seeing things they shouldn't. I know just a couple of things from Ms. Olson's comments. And I'm probably not going to, I probably didn't write this down exactly how she said it, but she mentioned that we live in a day and age of visual coverage of everyday life. I don't know that that's really an argument for broadcasting a trial. I don't know that that's a good thing. And we could probably spend hours talking about all the social implications of the fact that we live in a day and age where everything is televised or put on a computer or a phone, and there's videos of everything everybody does. I don't know that that's really an argument that we should contribute to that. I don't think it's a good thing. I don't think it's a good thing to turn everyday life into a circus. And I think that broadcasting, even if done responsibly and respectfully, will contribute to that. I just finally end on noting, she mentioned the Kyle Rittenhouse case. I brought this up the last time we litigated this. It's interesting because that judge said afterwards, and I quote, "I'm going to think long and hard about a live television trial again next time. I don't know. I've always been a firm believer in it because I think that people should be able to see what's going on. But when I see what's being done, it's really quite frightening." That was Judge Schroeder from the Kyle Rittenhouse case. My understanding is he said that in regards to the context of a jury bus being followed by some reporters. And we're certainly not alleging that any of Ms. Olson's clients are going to do that. But the reality is by broadcasting, we absolutely will create more of this circus type environment, more of this reality TV environment, this true crime obsession. Again, we believe the media should be there. They should report. They have a right to be there, and the public has a right to have the media there. The public has a right to an open trial. We would ask the court to maintain its current order. We believe it was a good decision then, and all the reasons that it made that decision then still apply today. Thank you.
All right, thank you, Mr. Wood. All right, counsel, I've been considering the decision on this issue. I am prepared to make a ruling today. However, I do want to take a quick recess to sort of gather my thoughts and prepare for the ruling on the motions. So we'll take a recess here for about 10 minutes or so, and then I'll come back on the bench with the ruling.
All right.
Was Jennifer, and she was able
Of a reconsideration of video and photographic coverage of this case, including the trial. A couple of notes the court will have in making this decision. The court has listened to arguments of the state requesting that we keep the case status quo. And I'll note we did conduct a trial in the Lori Vallow case, which was initially joined with this case, later severed and tried in Boise. During the process of those proceedings, in order to allow some additional access, the court did permit a broadcasting on a limited basis of that trial to two separate locations where the public could view outside of the courtroom. One was a location in Ada County in their courthouse, and then a second location in Rexburg, Idaho. And there were certain reasons for doing that, mainly the fact that venue was changed and the case was taken so far from this location where the home counties are. So that factors into the court's decision. This is now a trial of Mr. Daybell. One of the big concerns I had also for the initial trial was potentially tainting jurors for what I knew would be a second trial coming up if the entire proceedings were broadcast from the Lori Vallow trial, concluding that anyone who had watched that trial or portions of it would likely be unable to serve as a qualified juror in this case. The court has also heard the request from the defense and the rationale for allowing broadcasting of the proceedings, including trial, and the court's considered the briefing and arguments submitted by Ms. Olson for her various media clients who are requesting the ability to conduct broadcasting and photography of the trial during the proceedings. A few things I'll note. First of all, under Idaho Court Administrative Rule 45B, the court has the discretion to make this determination. That rule reads that the presiding judge may, at his or her discretion, limit, restrict, or prohibit audio, video, audio or visual coverage of any proceeding. And those decisions are not subject to appellate review. I am compelled by some of the arguments that a difficulty in moving a trial about 350 miles away from where we currently are certainly restricts access by certain individuals that wish to attend. The argument by Mr. Pryor that the defendants family members that would like to see the proceedings is a compelling argument. I know from the last case also there are other individuals, family members of victims, family members of defendants, and others very interested in the case or connected to it, which were unable to attend because of the location. I'll note also that the court still has under advisement, and we'll hear argument later this morning about changing venue, but as I sit here to make this decision, we're currently scheduled for trial to occur again in Ada County in this case. In balancing out the requests here, the court is determined or has made a determination that in order to provide adequate access, the court is going to permit that the trial be broadcast while it occurs with certain restrictions. First, the court is going to be in charge of all equipment and the broadcasting of that. I'm not going to allow that to be conducted by any third parties. The court has the equipment to do so. We did that in the previous trial when it was broadcast to those other locations. It worked well in all the reporting I got back from those that attended and those that ran the system. And with the equipment to do that and the court's own website, which provides an ability to stream it live from the State of Idaho Judiciary website, public is given free and unfettered access to view the proceedings that way. So with that in mind, the court won't allow any still photography, given that the matter will be broadcast on video through the court's own system. And in addressing some of the other concerns as it relates to any microphones placed by any media or third party, of course, those will not be allowed because the court's going to use its own equipment to broadcast the proceedings. And in addition, there were concerns about the exclusionary rule. So witnesses who would be testifying not being allowed to view the proceedings before they testify. I'll note that was already a concern in the first trial with Ms. Fallow, and we had an affidavit that addressed that and required each witness to certify under oath that they had not viewed the proceedings, and did in fact run across a few witnesses who were not able to do that and took those matters up outside the jury. I think that system worked well to make sure that there was not any improper influence on testifying witnesses. So the court will employ that same method of allowing witnesses to testify only after they've been able to certify under oath that they haven't been tainted by viewing previous testimony. There will be some additional technical terms of how the court will allow the broadcasting, and those will be followed up on in a subsequent written order that I'll enter into the case for trial. Going forward with other pretrial hearings, the court will take those up on a case-by-case basis, but this will be the ruling for the trial and how publicity will be handled. So I have balanced out also the concern of certain witnesses who don't wish to be captured on recording forever, and I understand that, and I've had to balance that out. I'd note at the last proceeding, they were also photographed whether they wanted to be or not as they went in and out of the courthouse because it's a public area, and the media was pretty persistent in trying to capture images and pictures of them. So there's really not any way to completely prohibit that. And while that's unfortunate for those that do not enjoy being on camera or all the publicity, that's just part of the stress, I guess, of being involved in a case like this, having to testify. So the court is going to amend its current order as it relates to the case. And as I mentioned, I'll follow up with some additional detail in a written order, but I wanted the parties to be aware of where this would be heading as we get closer to trial. So that will be the court's ruling on the motion at this time. Mr. Wood, does the state have any questions on that ruling?
Not at this time, thank you.
Thank you. Mr. Pryor, any questions?
No, Your Honor.
Okay.
Thank
And
you,
Ms.
Chatty
Olson,
Daddy.
any comment or question? All right, thank you.
Wow, she's so
That will conclude
disappointed.
the first motion then. The next motion we will bring
Okay.
up.
I'm going to end this right here. All right. Yeah, because you know, in some way, yeah, definitely cameras in the courtroom, Justice Jane. We're going to have cameras with Judge Boyce, and we're going to have cameras with Judge and the Idaho 4, the prosecution of Brian Koberger. Let me say this very quickly, and then we'll move on to the next topic. But I think not so much in this case, because I think we all agree. How do you get over, really, how do you get over that these two babies were found in on Chad's land? How do you get around that? You don't. You do. I mean, let's be honest, you don't. But he is entitled, to a trial by a jury of his peers. But in the case of Brian Koberger, that's what I want to say. In the case of Brian Koberger, man, there is a true crime community that is really built around this fact that Brian Koberger, the evidence against Brian Koberger is not clear cut. Now, I'm not getting into that. I think they got their guy. I also am very disturbed by the story that Dylan has given. I think there's definitely evidence that puts Brian Koberger at least in that neighborhood on a regular or semi-regular basis. So in terms of antecedents, look, the guy was fascinated with serial killers. He wanted to be a criminologist. There's some thought psychologically. There's some orientation toward true crime. We saw with Barry Morphew. I showed you the video he watched, and lo and behold, the place where the young woman was discovered was a spitting image to where Suzanne's body was discovered. How do you account for that when he's literally living in the middle of rugged mountains where he could drive an hour away from his house and drop her body off a cliff and no one would ever find it? There are places in the backcountry human beings cannot get to short of a parachute. So that was there for him. He's a backwoods guy. He knows how to get up there and get into those places. But where did he choose to dispose of her? Allegedly, in my opinion, a place that looked exactly like the case that he was listening to. It was recorded on the pen. They know he heard the story. They know which episode it was, and they went and watched it. And man, crazy. So that's how he came up with that area, because he said this is an area that people would say, oh, nobody would, he would not dispose of her here. It's a wide open field. It's easy to get to. That's why they wouldn't suspect it. I guarantee you that's what went through his mind. But anyway, in my opinion, but in the case of Koberger, they need that to be public. Okay. Oh yeah, Fancy Nancy. I put a video up with it. Yeah, it's chilling. But anyway, before I go on a tangent here, in the case of Brian Koberger's prosecution, the sizable number of YouTube subscribers and creators, and these creators are intelligent, experienced people in their own right. They were police officers and whatnot. they are really questioning the arrest affidavit. They're really questioning some of this evidence that they have against Brian Kohberger. Some of the decisions and choices that were made by police. I think the medical examiner, my butt, I think that is going to be highly questionable. We need a big old spotlight shining in that courtroom in Idaho when they prosecute Brian Kohberger. Otherwise, there's going to be a large number of people that are going to be highly suspicious of the steps that both sides took. So I think not in the Chad Daybell case, because I think we probably all know the reality there. But I think in the case of Brian Kohberger, and maybe this is part of what, motivated Judge to make his decision. I think having the cameras in that courtroom are going to be invaluable in helping everyone rest easy with the verdict. You know what I mean? Once they see the full case that the prosecution lays out, whether whether the defense is able to exonerate Brian Kohberger or whether he's found guilty, either direction. I think having it out, just like during Johnny Depp trial, having it out there, letting the general public see what they have, what the steps were that they took, that can go a long way to help people rest easy with the outcome, right? So I think, I think it's a really good choice. So, and then of course, the selfish part of it, we like to watch trials. So there you go. So we got 2 really great trials, interesting trials to watch upcoming. So now what I want to do, I know I'm being so productive today. So now what I want to do is I'm going to end this live. I'm going to come back. We're going to do the next part of the Chad Daybell preliminary hearing. All right. Okay. I'll be back. Me and Arnold. See you later. Bye.